of the big problems we had back then was people weren't told what the problems were. So what the government did as a result of RCMP wrongdoing and the fact that the procedures weren't fair, it all sort of got put together. In 1984, they created the Canadian Security Intelligence Service and set up an agency to be able to determine for non-citizens whether they posed a threat to the security of Canada. That's when they introduced secret hearings. There were, in World War II, secret hearings against Italians and others who the government, and of course there was the internment of the Japanese. But it became an ongoing, regular way of proceeding in national security matters in 1984. It wasn't just non-citizens. The Security Intelligence Review Committee also had the right to hold secret hearings in relation to civil servants, federal civil servants, who needed clearances to be able to keep their jobs. The practice in that proceeding was that CSIS, the security service, would present evidence in secret. The person didn't know what was being said. A decision would be made. The person would be asked to answer what they didn't know was being said, and then a decision would be made. The person would be deported, or they would lose their job in the public service. In 1992, the Immigration Act was amended to include member in a terrorist organization. I don't know if Jeff knows a lot about American immigration law, but they have this concept of material support for terrorist organizations, so that if you helped train doctors to be able to take care of the sick in a war zone, that's material aid for a terrorist organization. We have the same concept, only it's actually broader. It's membership in a terrorist organization. When that came in, I think it was fair to say that the focus was on racialized refugee communities in Canada. So if you look at the ones that were the most repressed in their home countries or their homelands, because they didn't all have countries, they were and had to flee and come to Canada to seek refuge. Those were the ones targeted by CSIS. If there was a violent struggle in the homeland, they were all suspected of being terrorists because of the violent struggle against repression. So the focus has been, for most of my practice, and I can tell you the number of quote-unquote terrorists in my office has exponentially increased as the years gone by, because the government keeps broadening its understanding of who's a terrorist. Focus is on Kurds from Turkey, some from Iran, Tamils from Sri Lanka, Sikhs in the 80s, it was the Sikhs from India, Palestinians, and now since September 11th, Islamists from the Middle East. The broad laws that they've passed have been applied in a very broad way. So what the court does is the court says, first of all, you have to be a member. The court has said it's not necessary to define member, so we don't need a definition. It's broad and unrestricted. It covers anybody who has any association. So I don't know if you read in the paper a while ago about the woman, Mrs. Joseph. Her husband was an elected member of parliament in Sri Lanka for the Tamil National Alliance, a democratic party. That Tamil National Alliance, because the LTT was proscribed and fighting a war in the country, the Tamil National Alliance made efforts to negotiate, to help negotiate a settlement between the LTT and the Sri Lankan government. Because they helped in terms of trying to negotiate an end to the conflict in Sri Lanka, her husband was a member of a terrorist organization because the Tamil National Alliance assisted in the negotiation process. She's a terrorist, a member of a terrorist organization, because she was married to him. That's how broad, I mean, it's hard to believe that that's where we've gone, but that's what the courts have permitted. And that's what's happening. That case is now before the courts. George Galloway's case was the other example of the law being applied in a really broad way. George Galloway was not only said to be a member of Hamas, because he passed money over to Hamas on the Viva Palestina convoy, he was passing it to Hamas as the government of Gaza, not Hamas as a quote-unquote terrorist organization listed as such in Canada. George Galloway is a secular socialist. He doesn't support the political views or religious views of Hamas, but because he was involved in that convoy, he was deemed to have been a member of Hamas. And not only did they go after him on being a member, also for engaging in terrorism. And that's the other problem with, no, it's engagement in terrorism, believe me. Engagement in terrorism is complicity. So if you I'm trying to think of an example. If you worked in a a medical clinic taking care of someone, that's complicity, because even though you weren't involved in the terrorist acts themselves, you may not have known about them, you may not have supported them, you may not have been involved in any kind of conspiracy. It's broad enough, the understanding of complicity, to target you as being a person who's engaged in terrorism. Someone who contributes, and some of these organizations are multifaceted, right? So if you talk about the PLO or the LTT, they ran civil governments for people. So they ran medical clinics, they ran community services, they ran factories. The PLO ran factories. So if you gave money to one of the medical clinics, you were a terrorist because you were complicit. Because if you didn't give them the money to help run the medical clinic, by giving them the money to help run the medical clinic, it freed up money for them to buy arms. That's the way the government looks at it. And it has been applied that way. Terrorism, the Supreme Court of Canada has limited to violence against civilians. But the court, in that sense, has broadened it by saying it's your membership in the organization need not be limited in time to when the organization was engaged in terrorism. So if you take the African National Congress, back in the 60s, 70s, it was involved in terrorism, according to what our government would say, because there were civilians that were harmed by the actions of the ANC. If you join the ANC today, you're a terrorist. There's a recent judgment from the Federal Court of Appeal that supports that view. National security, the Supreme Court of Canada, I was involved in the Suresh case. He was a Tamil. And Canada was trying to deport him, the government was trying to deport him to Sri Lanka, where we all knew he would be detained and tortured. And it went up to the Supreme Court of Canada on the issue of whether he could be deported to face torture. And we argued that national security, he was being deported on the basis that he was a threat to Canada's national security. And the issue was, historically, national security has been a threat to the nation. So we argued, you know, apply that. Suresh, what's going on in Sri Lanka has nothing to do with Canada. He's not a threat to Canada, and it doesn't justify deporting him to torture. We're not in a state of war in Canada. There might be one in Sri Lanka. The Supreme Court said, we know that's the way it's always been looked at. That's true in terms of national security, but we think reciprocity is important. So that if Sri Lanka thinks he's a threat to national security, it'll help Canada in terms of reciprocity to be able to protect Sri Lanka's national security by deporting Suresh to torture. On top of that are the secret proceedings. We had to go up to the Supreme Court of Canada in order to get the right to have a lawyer in the secret part of the hearing to try and defend the interests of the person. And I can tell you that the judges in the federal, I have a particular dislike of the federal court. I'm in that court all the time. If you ever believed, no, I think it's the court that's been established in order to support the federal state. A lot of them are ex-politicians. Most of them are friends of the politicians if they weren't ex-politicians themselves. And I can't say it's all of them. There are certainly some good judges. But you know, if you believe that the courts are really there to support the state, come and watch the federal courts, because that is really what's going on. They are supporting the state. So not all, like I said, there are some very good cases out of the courts. Some very few good cases out of the courts, but most of them are problematic. So what came out after the Supreme Court put lawyers, they struck the law and said there have to be lawyers in the secret process to defend the rights of the person, not just the judge and the prosecution. What came out was CSIS had been lying to the court, and the court let them get away with it because they didn't test the evidence themselves. The judges defended their right to do these secret hearings without anyone testing the secret evidence. And it turned out that they'd all been messed up by CSIS. CSIS hadn't told them the truth. In every single case of which I know, there were serious problems in terms of what was presented to the court that only came out after there were lawyers put in there. So the judges weren't doing their job. The other thing that was going on is, and I'm affected by this, my clients are subject to the security certificates. We find out that CSIS, who is entitled to intercept the client's conversations once they've been released, because the court has required that their conversations by phone be intercepted, is intercepting the solicitor-client conversations as well. So for more than 2 years, they were listening to everything I said to my clients on the phone. That's how it works. since September, I sort of have this theory that the government tries to do things first, or they experiment first with non-citizens. They're vulnerable, they don't have a voice, they don't have a vote. People often think there's a controversy about how many immigrants we should have in Canada and whether they're good for the country or bad for the country. So they're an easy target for the government. But once it works and there's a body of law developed that supports the kind of repressive measures they want to put against non-citizens, like justifying secret hearings, they start passing laws against citizens. And that's what we have in the Anti-Terrorism Act. They have secret proceedings in the criminal context. The whole issue around politicizing the case that you can be deported because you're a member in a terrorist organization, the anti-terrorism provisions provided for enhanced punishments if your conduct was politically or racially motivated. So it ties it all in. So and they know that they're going to have a really good chance of succeeding in court because they've succeeded for the last 20 years on the backs of non-citizens. They've got a good, solid body of case law all the way up to the Supreme Court of Canada that allows them to do this. And then they just move over and start doing it with citizens. And that's what's been happening. I think that there has to be an effort to sort of to try and push it back. I don't think that I, as a lawyer, or other lawyers in the country arguing legal cases is the solution. I mean, do you know how long it took to get the Supreme Court to say that the secret hearings were unconstitutional? That was first argued in 1992 when the Act came out, when the Act came in, or when the Act was broadened to include the federal court instead of the Security Intelligence Review Committee. It wasn't struck until 2008. We got turned down at every level of court again and again and again. Leave was denied in the Supreme Court of Canada in a number of cases before they finally decided to hear it. The courts aren't the solution. I can tell you the only reason we won those cases at the end of the day was because of community support. By the time the secret hearing cases went up to the Supreme Court of Canada, there had been a whole caravan of people who'd gone across southern Ontario, going to libraries and high schools and little towns that never see these kinds of issues, talking to students, talking to teachers, talking to church groups and communities. They had done a lot of groundwork. There were editorials in the paper cutting up this process, even in newspapers like the Star and the Globe, saying this process wasn't a fair process to have secret hearings. It was the groundwork that led to winning in the Supreme Court. They knew that there was, when even the Globe and the Star are saying this is an unfair process for non-citizens, that they know that there's a lot of discontent about this kind of thing. But I guess the problem I have is that it's just a constant struggle. Like it's, you win one point, like we won this, we now have, but the government will never give you what the court said that you should have. They twist it so you don't get it exactly. So now we have advocates in the secret hearings, but we're not allowed to talk to them as defense counsel. So, like, if they want to talk to us, they have to go to the judge, tell the judge what they want to talk to us about, where they can talk to us. So, like, they always add something. There's always something added, so it doesn't work the way it's supposed to work.
5 minutes.
5 minutes, okay. I just want to say something else, too, about racial profiling, because I think that has been what drives a lot of the things that have gone on since September 11th. In the criminal context, there was an important case that went before our Court of Appeal for Ontario, the sort of traditional historic courts that I do think are not as affected by political appointments, but more based on merit. But the Ontario Court of Appeal characterized racial profiling as people who are targeted because of racialized characteristics, especially black people in combination with other factors that provoke police suspicion. So it's driving while black. You have a nice car and you're a young black guy, that's why you get stopped by the cops, and then the cops stop you and they find something against you. The presumption is because you're black, you're carrying drugs. It's that kind of racialized profile. It's not acceptable in the courts. The Ontario Court of Appeal in the Brown judgment back in 2003 said, look, we've got to recognize this is happening, it's not fair, and when you see this, it's hard to prove, but when you see someone who's been charged with having 2 licenses, and that's the only charge against the person, how does the cop know the person has 2 licenses. They don't until they stop the car. They stop the car because the person's black. So that's how they know. So that's what racial profiling is about. It's not acceptable.